here's my pre-show topic. You ready?
Yeah.
In our first episode of 2018, this is episode number 44, title Everything We Know About 2018, we each made a few predictions. Now, Richard screwed up big time because all of his predictions were about crypto, which we don't talk about on the show anymore. So we'll never be able to revisit those to see if they came true. Meanwhile, my prediction that the Apple HomePod would launch in 2018 and would be insanely good is accurate. I have a HomePod and it's the best.
Is it though? So, yeah. I mean, the stories I've been reading...
No, it didn't mark up my table. Yeah. It sounds very good. I didn't expect Siri to be able to do anything anyway. The sound is very good, and it didn't mark up my table.
This is sort of akin to someone predicting Donald Trump will be the best president ever, and then after the fact being like, listen, I didn't expect him to be that good. You know, he didn't burn down the White House, and, you know, I didn't expect him to enact any policies that were good. Anyway, I was right. He's the best.
Here's what I wanted. I wanted a cylinder that could turn on and off some of my lights and could play Apple Music. And there's only one cylinder that does that. And I own it. I got exactly what I was looking for. It's insanely good. Go back and listen to episode number 44, Everything We Know About 2018, where you could hear my extremely accurate prediction that the HomePod would launch in early 2018 and it would be insanely good.
This is, AJ, I think you're stealing Ruchit's stick where, you know, you like hawk your goods.
No, this isn't my goods. I'm not selling my HomePod. I like it too much and I want to keep it.
I'm willing to have the government take away AJ's HomePod for the greater good. And if AJ refuses, he doesn't actually believe in socialism. Let's talk about your cases, AJ.
Well, okay. So first we have a little bit of follow-up. In episode number 7, we talked about a case for one of an Oxford comma. We have this case in Maine. No one knew if the drivers got overtime, but it turns out they do get overtime. The case settled for $5 million. The drivers got overtime. The Maine statute was missing a comma, but they found it in a private settlement.
So this issue of the comma did not actually get resolved through the court system. That is too bad.
Yeah. Rich, why don't you give us the facts of Hanvey Scott?
Yeah, so Hanvey Scott is it's a series of ex-felons in Florida that sued because the Florida statute. So a few things. First, Florida has a law that says that if you are an ex-felon, you lose your right to vote. But the Florida Constitution has another provision, or has a provision, which says that those rights can be restored. As long as it is done pursuant to a specific procedural rule set. Now, the Florida governor's office gets to create this procedural rule set. And so they did. They created a procedural rule set through which Florida people who are felons or ex-felons and that they have served their time can get their right to vote restored. And so what this case is about that, AJ.
Yeah. So the federal district judge said that the right to vote is a First Amendment protected right. It's an associative right and a speech right. So it's protected by the freedom of speech and the freedom of association. And they said that the scheme for giving the franchise back to felons was unconstitutionally vague and gave unconstitutionally broad discretion to the governor's office and to the board.
So I'm looking at this, right? This board, the governor apparently sits on the board, and at one clemency hearing, he there was a man that cast an illegal ballot, I guess, and 3 years later he sought restoration of his voting rights. He went to the state executive clemency board where Governor Scott asked him about his legal voting. "Actually, I voted for you," he said. The governor laughed. "I probably shouldn't respond to that." A few seconds passed. The governor then granted the former felon his voting rights.
Yeah. So this is really interesting. So
I think the lesson here is just say that you voted for the governor, whether you did or you didn't. You know what I mean? You have your rights back. It's pretty easy. I don't know what this court... I'm kidding, obviously. Go on, AJ.
To me, I think the thing that stands out is that the opinion borrows a lot from other free speech jurisprudence. And it says that, the state can have a policy that runs afoul of the freedom of expression, even when it's not shown that it's limiting someone's particular exercise of their speech rights, right? So you can have a scheme that in itself is just overbroad or unconstitutionally, gives unconstitutional discretion to decision makers, right? So the idea here is that let's say you have an ordinance where it says the mayor will just decide who gets permits to hold events in the public park, right? And so there's no criteria. There's no like formal process. There's no deadline for the mayor to make a decision. All it says is that you go and ask the mayor, and after some period of time, it could be a while, it could not be a while, you might get to hold an event in the park. And what the jurisprudence says on the First Amendment is that is unconstitutionally vague, and in fact it's facially impermissible, right? You don't even need to go and find someone who has suffered viewpoint discrimination at the hands of the mayor. You just know that that whole scheme just can't be implemented. So I think that's interesting, right? And so the court borrowed from that concept and said, the rules for clemency in Florida say that, there's no deadline for the board to rule on your request for clemency. There's no guidelines that structure their decision. There's no factors they have to consider. In fact, the rules say that there is no limit to the board's authority to grant or deny a request for the franchise. And the court said that is impermissible. I think that's a very interesting decision.
Yeah, I think this whole broader policy of taking away felons' rights and having them just sort of completely gone, either forever or even after they have served their time, is pretty troubling. And I think the court points out some of these things. These are folks that have to live, by the laws that everybody else sets, but they don't get to vote on those laws. They have to pay taxes. They have to live in society. And one of the parts of the social contract that we have is that, you obey the rules that society creates, but you have the right to have a say in the creation of those rules, and that includes voting. And that's just that's an important part that is lost.
Let me ask you guys something. Do you think that a state should ever be able to take away a right to vote, even so, while they're serving time in prison for whatever crime they committed? Do you think they should have a right to vote there then?
I think that's up to a state. I wouldn't do it, but it's up to a state. I guess I would say that, for them to not get their right to vote back after they've served their time, I think that is actually wrong. I think they should get their right to vote back after serving their time.
I mean, so to play the devil's advocate then, Ruchit, I think a state would say, well, part of the punishment for the crime is you lose your right to vote. And you obviously agree that the state has the right to make that part of the punishment, at least for a period of time, right? States that extend that inability to vote for a longer period of time are saying, well, that's just part of the punishment, right? It would be like you go to you commit a crime and you go to a prison for a year, and then after prison you're on probation for 2 years after that, right? No one is saying that your probationary period should only last the amount of time that you're in prison.
So here's the thing on that. The 14th Amendment says that felon disenfranchisement is okay, right? Section 2 of the 14th Amendment says that, it doesn't just say states can disenfranchise people, but it says that people are disenfranchised based on their conduct, don't count towards the apportionment of voters in the state. And I think, for the most part, the purpose of that was to remediate the 3/5 clause. I don't know that for sure, but my guess is that the purpose of that clause is to remediate the 3/5 clause, right? Because the 3/5 clause said that states can disenfranchise and remove all political rights from slaves in their jurisdiction, and nevertheless they could still count 3/5 of each slave towards their population for congressional apportionment purposes, which would inflate the representation of those states in Congress. And what this says is that when you disenfranchise people, then they don't count towards the population of your state. Right? It's sort of the opposite from what the 3/5 clause does. So, but part and parcel of that is that Section 2 of the 14th Amendment does strongly suggest that states can disenfranchise felons. Now, do I think states should disenfranchise felons? No. And, does the 14th Amendment say they have to disenfranchise felons? No. The judge in this Florida case said that states could have a scheme where they disenfranchise felons, and there's no process for reenfranchising them or doing vote restoration. And that would be fine. It's just that if you are going to have a vote restoration scheme, it can't be unconstitutionally capricious. Now, I don't think that's right. I think that if you find that these speech rights are an associative right under the First Amendment, then I don't think you can be permanently disenfranchised. But I think the state of affairs, at least under this court opinion, is that you really could disenfranchise people forever, and it would be appropriate under the Constitution.
Yeah, but it seems to me that Ruchet is drawing the line at while they're in prison they can be disenfranchised, but when they get out they shouldn't be disenfranchised. Is that right, Ruch?
Yeah, that's I guess I'm not drawing the line there. Well, I'm saying that one could. I guess I'm not saying that they should have their rights taken away. I'm saying that that is okay by me at least, but it's not that should be permanent.
Mm-hmm. Yeah, well, that's what I mean. You're drawing the line.
Sure.
Why is that the line?
I guess I would say because it's one thing to have it be part of your punishment while you are serving that punishment, but for it to be basically permanent, a permanent taking away of your rights, that goes beyond sort of your quote unquote prison sentence, let's say, right? So if they say that listen, you've committed a crime, you can't own property ever again, or for the time you basically can't exercise a free speech right ever again. Do you know what I mean? It's one thing to say that you can't do something for some amount of time that is commensurate with your prison sentence and the limited rights that you have while you are in prison as part of your punishment, but for that punishment to basically be forever, as it relates to the right to vote, is troubling for me because ostensibly you get out of prison and now the state passes a whole bunch of other laws, which, you don't get to participate in the making of.
I mean, you don't get to participate in the making of them while you're in prison either.
Yeah, I guess that's true. I mean, maybe it's an arbitrary line, right? I mean, I guess I don't deny that. It seems like a sensible place to draw the line, I suppose, is what I would say.
I think this is interesting. I think there are a couple angles we could take here. I mean, so first of all, the court says that it's a really an issue of first impression whether there are First Amendment rights associated with voting. And so the Supreme Court has sort of hinted at it in the past, but never outright come and said that there's a First Amendment right, either associative or speech-based, for voting. But if you start on page 16 of this opinion, there's a very lengthy discussion of Citizens United. And the argument basically breaks down to, well, come on. I mean, if political donations are speech, then how is voting not speech? And I thought that was a very interesting tack. I think it's also accurate. I mean, I think Citizens United is wrong, and I don't think that...
That makes a ton of sense, frankly.
I mean, to the extent that Citizens United exists, I think that this is a valid counter-argument. I think Citizens United is wrong, and so I think leaning on it too heavily would make the rest of the decision fall apart. Luckily, I don't think this court does that. But anyway, I think that sort of the left should try to weaponize Citizens United. I think this is sort of smart, where the alternative is to just, not... If you hate the opinion so much that you never cite it, then you miss opportunities like these to rely on it. I mean, what do you think? Right? I mean, do you think the logic follows that if political contributions in the Citizens United sense are speech, then surely voting is speech, right?
My question maybe is a little more basic than that. Is why is this analyzed in the framework of speech? Why isn't there an inherent right to vote?
Good answer. Okay. Because I think if you don't associate it with the First Amendment, then you don't get to have a facial challenge against the process, right? Because the 14th Amendment already enshrines the concept of felony disenfranchisement, right? So you can't say that felony disenfranchisement is constitutional. In fact, the Constitution says that states do that, and here's how to use it when you're doing the census, right? So in order to have a facial challenge against the scheme, the only way I can think of to sustain one is to say that it's unconstitutionally vague or unconstitutionally structured in a way that leads decisions to be capricious. And there's an entire framework for striking down policies like that, but that framework is based on the First Amendment. Right. So what the court has said in the First Amendment is that you don't have to find someone in particular who has suffered viewpoint discrimination. You can just say that the way that this jurisdiction makes its decisions about in the realm of speech can be unconstitutional, even if no one in particular has suffered discrimination. And that's what the court said here, right? This is a facial challenge. So there's no one in particular who has been unconstitutionally disenfranchised. It's the whole system of vote restoration that is being struck down here.
Yeah, it's an interesting argument. It's an interesting kind of way to look at it. I like the Citizens United angle of it, for sure. I wonder if that could be applied also to sort of some of the restrictions that the government places on, your ability to have a rally, for example. I mean, if money is speech, then, it goes to say speech is speech.
Yeah. I mean, I think that's exactly what the court says. I think this quote is sort of telling. It is inconsistent to find that corporate expenditure spent during a campaign or filling out voter registration forms are core expressive activities, but that voting, the end results of these other protected activities, is non-expressive. There is some measure of expressive activity in winnowing out and finally rejecting all but the chosen candidates.
What does the court say in terms of who you're expressing your act to?
I think the court thinks about it more as an associative right? It's your right to associate with and choose to elect and participate in the election of candidates of your choice.
Doesn't that break down the Citizens United analogy then?
I don't think so. Why would you say that?
Well, because if the gist of that analogy is that if money is, you're spending money is an expressive right? It doesn't have anything to do with whether voting is an associative right.
Maybe not. Okay, so what do you want to do? What do you think is going to happen? I mean, do you think obviously this will get appealed. What do you think will happen on appeal?
I don't know.
I have no idea, dude. That's really interesting podcast material.
All right, Tom. League of Women Voters versus Pennsylvania.
Never heard of it.
Okay. So in League of Women Voters, we talked about, take a step back. We talked about partisan gerrymandering a lot on the show before. Richard thinks it's bad, and I think it's bad. Tom thinks it's bad. So the League of Women Voters versus Pennsylvania is a case where the Pennsylvania Supreme Court has said that the partisan gerrymander for the federal congressional districts in Pennsylvania violates the Equal Protection Clause and the free and fair elections clause of the state constitution. And so what the court says specifically is that, we understand that the Supreme Court is still working out what the federal standard for unconstitutional partisan gerrymandering will be. But in the meantime, we've decided that the state constitution of Pennsylvania gives us a clear guideline that we can use to strike down the voting maps in Pennsylvania. In fact, here's what the Supreme Court of Pennsylvania said. The people of this Commonwealth should never lose sight of the fact that in its protection of essential rights, our founding document is the ancestor, not the offspring, of the federal Constitution. We conclude that in this matter, it provides a constitutional standard and remedy, even if the federal charter does not. But I think that's interesting. I think that is, I don't think you can replicate this strategy in other states. I think not,
Some creative lawyering for sure.
Yeah, I mean, so this opinion says that only about 3 other states, in addition to Pennsylvania, have something analogous to the free and fair election clause that the Pennsylvania Constitution has. But, I think this is persuasive. I think this is persuasive that more and more judges in more and more jurisdictions, and now here in a state jurisdiction, are finding that partisan gerrymandering is a big problem.
Does anyone know if Pennsylvania elects its judges?
Let me check real quick.
Yeah. They're chosen by partisan elections.
Oh, neat. Well, those people would really care about their districts.
I liked these 2 cases that you brought up, AJ.
They're just too good?
No, I think it is going to be interesting to see kind of how they proceed. So one of the things that I've read a little bit about on the Pennsylvania situation, which, I've really only cursorily read about it, so I'll talk about it if you guys know something about it. But I don't know much about it, so it's more me asking questions. But in the Pennsylvania situation, I hear that the elected officials are so pissed off at the judges that they're threatening to either recall the judges or impeach the judges. Or do you guys know anything about this?
Yeah. Okay. So this is very interesting. The political fallout from this whole situation has been totally fascinating. The president pro tempore of the Pennsylvania Senate sent a letter to the court that was basically like, we're not going to help you apply your order. Like, we're not going to supply information that would be helpful in drawing remedial maps. And the reason why is that we think that the court has usurped the constitutional power of the legislature, which is tasked with drawing the maps. And so that's going on. Meanwhile, there's some like bit player in the Pennsylvania legislature that's been trying to whip up colleagues around impeaching the Democratic members of the Pennsylvania Supreme Court. So a lot's been going on. Also, I think February 12th was the deadline for the legislature and the governor to agree on a new set of maps going forward. And they were not able to reach an agreement. Basically, the Pennsylvania legislature put together a set of maps that were basically as partisan as the existing maps. The existing maps have 13 Republican seats and 5 Democratic seats, and it looked like the remedial maps proposed by the legislature would have not changed that. And so what they ended up doing is Wolf, Governor Wolf of Pennsylvania ended up saying that he, wouldn't support the legislature's maps. And so now, the court's going to have to appoint a special master to do the mapping. And this is like a whole thing's a cluster. Meanwhile, like they need these maps in time for the like March special election. This is like crazy. So there's like someone who's like, Pennsylvania 18 is going to have a special election in a couple weeks. Connor Lamb is running against is the Democratic candidate. I can't remember who the Republican candidate is, but they're gonna have an election in a couple weeks. No one knows where to be spending their money because they don't even know what the shape of the district is.
Yeah, that's very bad. So do we know are they going to succeed in removing these judges, or like what are the machinations, so to speak? What's up there?
This is all like. Nothing's going to happen. They're not going to impeach the judges.
Do you think it's posturing? You think it's posturing?
I mean, even if it is an empty threat, it's pretty bad that you have elected leaders who are threatening to remove judges because they don't like a decision that they made.
Yeah, this whole thing is pretty nuts. Sidebars?
I thought we were gonna not do those today.
Oh my gosh, look at Richard's sidebar. Dude.
I have a sidebar, I do have one. You asked me to have one.
What's your sidebar, Reach?
So it's a link to the article about these Brown students that wrote an open letter saying that this person named Guy Benson should not be allowed to speak on their campus. So here's kind of the beauty. So this is their letter in their this is their op-ed in Blue Stockings magazine, which I assume is a Brown magazine.
It looks like a blog.
And by Brown, I mean Brown University magazine.
It looks like a blog.
No, it seems to, I don't know, dude. It seems to be a magazine. It's called Blue Stockings magazine. Do you think they're lying about the fact that it's a magazine?
We call ourselves a podcast.
Which is factually true. We are.
Wait, hold on. bluestockingsmag.com/about/mission-2/. Blue Stockings is an anti-oppressive publication. It's based in Providence, Rhode Island. It challenges dominant media narratives.
So today, February 13th, 2018, the Brown Republicans and the Watson Institute for International Public Affairs are hosting an event entitled The Millennial Conservative, a Conversation with Guy Benson. He is the co-author. Now, get this. This is the title of the book. End of discussion. How the left's outrage industry shuts down debate, manipulates voters, and makes America less free and fun. And so the response to that is to block this person from speaking. They say, we will not stand idly by as our proud history of student activism is belittled and the real emotional, physical, and psychological needs of marginalized students are denigrated as illogical and irrelevant. We, the undersigned, are staunchly opposed to this event. We consider Benson's invitation yet another iteration of a conversation that is misguided, narrow-minded, and explicitly dangerous.
Okay. So your sidebar is you just want to troll a bunch of brown students? Like, I don't get it. Where are you going with this?
No, my sidebar is that these brown students are wanting to silence a person who has written a book about how the left tries to silence people. And there's an irony there that's kind of funny.
So what's my takeaway?
Your takeaway is that at least in this situation, you have a college university campus where some students, just 18 it seems, that have signed this letter, do not want to let people they disagree with speak on their campus. I think that's bad. I think they should let the man speak.
So my big takeaway is that there are 18 people in Rhode Island that don't like Benson.
No, that they're trying to silence him. Yeah, they're trying to keep him from speaking on their campus. And the funny part of it is that his book is called "End of Discussion: How the Left's Outrage Industry Shuts Down Debate."
So it's funny because he has a provocative book title.
Do you think there are more or less than 18 people that find it funny?
Probably more. There's a deep irony that they are outraged and they're trying to shut down debate by preventing him from speaking, and that is indeed the title of his book.
No, but okay, let's pretend you convinced me to care about this. This article in bluestockingsmag.com/2018/02/13/silencing and free speech / right. Let's say I care about this. What do I like? What's my next step? Like, what would I do with this knowledge? Like, should I go to Rhode Island? Like, I don't understand. Like, what's the next step?
I think you would, if you knew a college student. I don't know. I think there's.
If I knew a college student, so I should just go find any college student like in Austin and ask them to be responsive to this Blue Stockings Mag article.
No. No.
Okay. I want to do my sidebar.
Okay.
Okay. Go to the Google Doc.
I don't want to do the choose your own adventure, AJ.
What?
I don't want to follow your links down some internet corridor.
Go to the Google Doc. Go to the Google Doc. You see where it says the Devil's Level is a card game where you control your depression level, horny level, and genius level to get levels of 666, the Devil's Level. Do you see that? Okay. Go to that link. Kickstarter.com/project/ blah, blah, blah. Go to that link.
AJ's doing that thing that you always accuse me of, Tom. AJ is hawking goods on the show. Not one good, but two goods.
Okay. Did you go to the Kickstarter page?
I got sidetracked, actually. I saw that I had some updates in my actual Kickstarter, so I went and read those.
No, go to the Kickstarter. Okay, so the Devil's Level is a card game where
has your cooler shipped?
Dude, don't you dare, man. That is the guaranteed best way to trigger me, okay? Is that stupid effing cooler. Oh my god.
The Devil's Level is a card game where you control your depression level, horny level, and genius level to get levels of 666, the Devil's Level. It's a card game on
what is that?
It's a card game. You could back it on Kickstarter. I backed it with an extraordinary amount of money because I really want.
Oh my god, dude!
They're at $152,000 of their $28,000 goal. There's only a few days left, so go right now. By the time we post this episode, actually the project will probably already be finished, which it'll be too late to back it. But anyway, go support the Devil's Level. He's the admin who runs the Twitter account behind the Devil's Level has done a bunch of interviews in the press, and so Newsweek asked, "Are you a skeleton, or do you just identify with the image of skeletons?" And admin wrote back, "Everyone is a skeleton. Think about it. I think that's New York Mag asks, "Who is the most powerful admin in the world right now?" And admin responded, "I am the only admin of DeShareZone. I don't know about any other sites." Which I think is true. He probably is the only other admin. So anyway, this is good stuff. You guys have an opportunity to be on the ground level of something truly extraordinary and culturally significant. And I think you guys are really wasting your time to be part of the zeitgeist.
So my fire pit thing is going to be here in May, dude. Like, they're actually going to meet their deadline.
Oh my god, no, we already talked about your sidebar. Now it's my turn.
No, this was my sidebar back in episode 12 or something.
Great. Did you talk about it then?
Yeah, I did.
Yeah, now we're talking about the Devil's Level. It's a card game where you control your depression level, horny level, and genius level to get level 666, the Devil's Level.
This actually looks really cool. And then they have this thing called a sunlight that they're doing, which is a solar rechargeable light. So when you're out camping or whatever, you have a solar rechargeable. That's amazing.
Wait, are you still talking about your coolest cooler?
No, Tom, dude. No, dude. I'm talking about my BioLite fire.
Okay, no, because I'm talking about the Devil's Level. It's a card game where you control your depression level, horny level, and genius level to get levels of 666. The Devil's Level.
God. Tom, what's your sidebar, dude?
So my sidebar is a YouTube video. You can click it in the show notes. Robin Thicke was sued arising out of his song Blurred Lines, which is kind of like a sleazy song that he did with Pharrell. And someone, I guess, sued him for copyright infringement. And there's some great quotes in this video Robin Thicke gives. For example, when I give interviews, I tell whatever I want to say, or I tell whatever I want to say to help sell records. And he's like, with all due respect, I was high and drunk every time I did an interview that year. And then at one point he's asked, do you consider yourself an honest person? Answer, no. So, it's a short 2-minute video of Robin Thicke being deposed.
Is this guy related to the dad in that Michael J. Fox show?
Yeah, he's the son.
Oh.
Anyway, watch the video. You don't have to tweet it out or anything like that. You can just watch it.
Dude, what a polite guy. They ask him, like, about, he's like, honestly, I didn't do a single interview without being high on both alcohol and Vicodin, he says. Do you think the attorneys, asked, hey, can you make sure your client isn't high or drunk when he shows up for this deposition? How do you do that, Tom? What is the right way to notice that deposition?
Yeah.
To notice a non-high, non-drunk deposition? Maybe we should talk about that case next time.
What, the Pharrell case?
Yeah.
I think the underlying facts of it are probably not all that interesting. My understanding is that Marvin Gaye had a song, and that was the basis of a lawsuit against Robin Thicke, saying that they copied the Marvin Gaye song. Some of the evidence, as you can see from this video, is that Robin Thicke went around saying that this song was copied from the Marvin Gaye song.
Why did he do that?
He was high on Vicodin and drunk. That's why. Or that's his defense.
Well, and his song was about how that when women say no, sometimes they mean yes.
That was his song?
That's what the blurred lines, the title of the song, the titular blurred lines, it's the blurred line between no and yes.
Oh, I see. All right, guys. Well, good job. I'll see y'all tomorrow, or at least I'll see Tom tomorrow, where we'll be launching the cryptocurrency.
No, not in the episode.
Tom, I think crypto's back, dude.
Is it?
For a while there, I thought we had missed our moment. When sometimes
all right, I quit the show. No, send me a text when you're done with crypto. I'm going to take my headphones off.
Okay, so AJ right now is so I don't know if our listeners are familiar with Michael Savage. AJ, are you familiar with Michael Savage? Tom, do you know about Michael Savage?
Yeah.
So Michael Savage starts every show, so he has a radio show. He's like a hyper-conservative. I think at one point he would have been considered far right, but today maybe he wouldn't. But in any event, he starts every show with, it's a radio show. He starts every show with, okay, I quit. I quit. Everyone, today's the last day. Don't call, okay? Just don't call. I don't want to hear any of your calls. I don't want you to come in here and tell me that I can't quit. I quit. Today is my very last day. And we're not talking about politics today. We're talking about tomatoes. Who likes tomatoes? I love tomatoes. Anyway, that's what he does.
I think AJ actually quit.
AJ just did that right here. With the I refuse. I quit. I quit.
All right. Tom said in the Slack you're talking about Michael Savage.
Yes.
Oh, AJ did quit. Like he actually tapped out.
That's what I said.
Yeah, I know. I said I was taking my headphones off, and I took my headphones off.
This is going to be a really short episode.
That's fine. We'll just do a short episode.
Yeah, you're right. We shouldn't feel bad about a short episode. Do you guys, what kind of pain do you think our listeners have gone through these past couple of weeks that we've been off the air? How much of an impact do you think it's had on their lives?
Do you think we should say why we've been off the air?
Probably not.
Isn't it just a bunch of excuses?
It wasn't a priority for us. That's what it comes down to. We should be ashamed of ourselves.
I had a kid.
Dude, we can't put that on the show.
That's why we haven't been on the air, because I've been in the hospital watching my kid be born. You put that on the show. My kid was born. That's why we haven't been on the air.
So how's she doing, dude? I haven't seen her yet.
Yeah, I don't see her much either.
Tom, we should go see her.
I've already seen her.
Oh, that's true. Tom's seen her.
When did you see her?
Yeah. We had Hoas.
When did you see her?
Like last week.
At Hoas?
No, Tom picked up hose and brought it to my house.
I ran into her at Hoas.
Dude. That would be so funny. Yeah, AJ, sorry I missed that stuff. I was in San Francisco. That's my excuse. Or maybe I was in DC, but I was in one of those places.
It's not a bad excuse. I'll take it.
So when do we get to see her? When should we go see her?
I mean, Tom already saw her.
But I mean, Tom, I think, don't you want to see her before she becomes a fully mature adult?
Yeah, Tom already did that.
Yeah, I already saw her.
Maybe one more time. I don't know.
It'll be a lot easier to go out and bring her places when she finishes getting her immunizations. But keep an eye out. You might see her on the street.
How old is she now?
She is
2.
14 days old.
Damn. How's Lily doing?
She's 8. Same old.
How's Jonah doing?
He's been better. He's been worse.
He's been better, is that what you said? Is he throwing a tantrum? Is he confused? What do you think is happening?
No, I think he gets it. He's actually been really good. He's been really good-hearted about the whole thing, because you hear a lot of kids that get really stressed out when suddenly they have a younger sibling. But Jonah's been fine. He's 8.
I think I got really stressed out when Rishi was born. I felt like I had all these responsibilities.
How old are you?
8? Dude, I was 8.
Oh, that's actually old enough to really cognize your responsibility. Yeah, that makes sense. Okay. Yeah, because Jonah's only 3 years older, so he has, all he knows is that he's tall enough to reach the light switch, and his sister isn't.